You wrote in 2008 the opinion in District of Columbia v. Heller, the majority opinion that said the Second Amendment means what it says. People have a right to bear arms. Question: how far does that constitutional right go? Can a legislature ban semi-automatic weapons, or can it ban magazines that carry 100 rounds without violating an individual's constitutional right to bear arms?
What the opinion in Heller said is that it will have to be decided in future cases what limitations upon the right to keep and bear arms are permissible. Some undoubtedly are, because there were some that were acknowledged at the time. For example, there was a tort called affrighting, which if you carried around a really horrible weapon just to scare people, like a head axe or something, that was, I believe, a misdemeanor. So, yes, there are some limitations that can be imposed. What they are will depend on what the society understood were reasonable limitations at the time. There were certain location limitations. But what
about these technological limitations? Obviously, we're not now talking about a handgun or a musket. We're talking about a weapon that can fire 100 shots in a minute.
We'll see.
The polling nationally shows that the public overwhelmingly supports a ban on assault weapons, a ban on high-capacity magazines, and some form of increased background checks for gun sales. And yet, that poll result notwithstanding, there's been no action on those priorities, even after incident over the last number of years.
Yeah, the NRA has this, the NRA is kind of set up at the pass. And sadly, in our case, the pass is our once representative House of Representatives. The NRA told all of their members the same thing in Maryland. We have rural areas in our state, large rural areas, the Eastern Shore of Maryland, Western Maryland, Southern Maryland. And the NRA was saying that the governor wants to take away your guns, the governor wants to take away your guns. So I pulled the hunting permits of everybody that was registered to hunt in our state, and I wrote to them myself, and I said, thank you for being hunters. Thank you for paying your permitting and licensing fee. Right. Without that, we couldn't preserve our open spaces. Now let me tell you about the falsehoods and the lies the NRA is telling you. And by the time we got done passing the bill, and it wasn't easy, hallways were jammed, traffic around State Circle was shut down by the numbers of people that were flowing in there. But by the time we got it done, they didn't even bother to send it to popular referendum, which they could have done to overturn it, because we had grown such a broad consensus.
Right, you won the argument.
We won the argument.
Right.
And nobody in Maryland to this day has lost their ability to hunt or take their kids out and teach them how to hunt.
Despite everything that they said going in.
Despite everything they said.
Surveillance cameras caught 19-year-old Darian Aguilar arriving by taxi at the Columbia Mall around 10:15 a.m., just after its doors opened. According to police, toting a backpack, he lingered for about an hour, sitting, standing, sometimes pacing. Police believe inside the backpack, a legally purchased Mossberg single-barrel pump-action shotgun with a pistol grip, similar to this one.
And today, the Supreme Court refused to take up a legal challenge to a city ordinance passed in 2013 by Highland Park, Illinois, that is a strict assault weapons ban. And by refusing to take up the case, this is a bit of a boost to advocates of gun control, because if the Supreme Court had agreed to take this case, it would have cast a shadow or a cloud over efforts to do this. But now there have been two federal appeals courts that have upheld local bans on assault weapons, or in the case of another appeals court, state bans on assault weapons. And the Supreme Court is, at this point, staying out of the fight. Now, Justices Thomas and Alito said the Supreme Court should have taken this case, that these kinds of weapons are among the most commonly owned weapons in America. They called them the modern versions of hunting rifles. And they said by declining to take this case and leaving the lower court ruling intact, it relegates the Second Amendment to second-class status. But this really is, in essence, a kind of a green light for advocates of bans on assault weapons from at least a constitutional point of view to continue to pursue them.
In a 2-to-1 decision, a federal appeals court panel ruled Maryland's law banning semi-automatic weapons and high-capacity magazines should have received more legal scrutiny. Today's ruling is reigniting the Second Amendment debate.
We're confident that ultimately our law will be held constitutional.
Maryland Attorney General Brian Frosh is prepared to make the ultimate appeal to the U.S. Supreme Court that a 2013 state law banning most semi-automatic rifles and gun magazines that hold a large amount of ammunition is common sense and save lives. But a panel of 3 judges on the U.S. Fourth Circuit Court of Appeals ruled Thursday, quote, "In our view, Maryland law implicates the core protection of the Second Amendment, the right of law-abiding responsible citizens to use arms in defense of hearth and home."
They've been the weapon of choice for mass murderers. They're not useful for self-defense. They just don't need to be in every household in the United States.
Mike Smeagol is a former state delegate and a guns rights advocate. He applauds the ruling.
The Second Amendment doesn't say hunting. It doesn't say sport shooting. It says that you shall not infringe upon the right to keep and bear arms. And it doesn't identify whether or not it's a AR-15 or a .22 pistol.
Thursday's ruling orders the district court judge Catherine Blake to review her prior ruling that upheld the weapons ban and apply the highest level of legal scrutiny when considering the state's reasoning for the ban. The U.S. Supreme Court has said that strict scrutiny is applied to laws that may threaten a fundamental right, so the government has to prove a compelling interest and that the law is narrowly tailored to achieve its result.
A Maryland case for the Maryland assault rifles ban finally had a federal appeals court send that ban back and reject it. They sent it back to the original court and told them they have to look at this again and apply a constitutional standard. Why is that important? You don't live in Maryland, you say. It is important because the United States Supreme Court has rejected taking all these cases for a very long time, and the most likely reason they have rejected taking these cases, despite the clear definition in Heller and McDonald ruling that firearms, the Second Amendment, is an individual right, and you cannot outlaw rifles that are in common use or firearms that are in common use, as it says in Heller, in common use. Let's be very clear. You are not going to get much more common use than AR-15s and AK-47s and whatever else the state decides is an assault rifle. Those are common use. The reason that the Supreme Court likely has not taken any of these cases out of Maryland and Connecticut and any of the other places that have these kind of bans are because there was no dissent in the lower court. There were no contradictory rulings. All the lower court rulings, because the judges were stacked by the Obama administration with anti-gun liberal judges, all the lower court rulings had held that these bans were perfectly fine. Well, the one in Maryland said that this ban is absolutely unconstitutional. You cannot ban assault rifles, quote unquote. You cannot just broadly ban semi-automatic rifles. That was unacceptable. So that got sent back. Now that created dissent in the lower courts, which now would likely lead to the United States Supreme Court taking the New York State SAFE Act case, which is being appealed, or was being appealed, we'll get to that later, and clarifying once and for all, hopefully, and it had the same justices that were in place for the Heller and McDonald decisions, so there's no reason to expect that they would not have clarified assault rifle bans, semi-automatic bans, these things that are in California and New York and all over the place were absolutely unconstitutional. It looked great. This was such good news for those of us who pay attention to Second Amendment issues and court rulings. And then the unthinkable happened. Justice Antonin Scalia passed away, and that completely changed everything. If you have not called your senator and told them, I don't care if your senator's got a D or an R next to the name, and called them up and tell them, do not confirm any Barack Obama nominee. I don't care who it is.
A three-judge panel last month sided with gun rights advocates when for the first time it determined that owning semi-automatic firearms, we're talking AR-15s, AK-47s, amounts to a fundamental right that deserves the highest level of protection under the Constitution. Now, however, an appeals court has effectively reversed course and has agreed to reconsider Maryland's new and stringent gun control law, which includes the ban on so-called assault weapons.